Okay, well, first of all, I think we need to work on changing some language. You don't need to fight for your daughter. Fortunately for you, you have a daughter who you love and who probably loves you very much. And really, it's not a question of a fight so much as it is trying to find, trying to educate, trying to persuade both, let's start with your ex, but if not your ex, maybe someone in authority like a mediator, like a social worker, like a child psychologist, or ultimately like a judge, that what's best for your daughter is for her to have a maximum relationship with each of her parents. Not more with you and less with her mom, or less with you and more with her mom, but a maximum relationship with both her parents. And specifically in that regard, I refer you to Section 17 of the Divorce Act, which says in very express terms, and this is federal legislation, it says that each parent should have as much of a relationship with their child as is feasible, and that each parent has a concomitant obligation to maximize the relationship between the child and the other parent. So in other words, if there is a parent between the two that is not working to foster the relationship between the parent and the child, the other parent and the child, then that parent's not doing their duty. So the question really isn't so much what do you have to do to fight for your daughter. The question is what can you do in order to rearrange her current schedule such that she actually spends as much time as she possibly can with each of you. And so the first thing that you should do is you should probably, if not speak directly to your ex, maybe speak to a social worker or a psychologist who works with children, who devises parenting schedules, and find out from them what they think an appropriate schedule will be given your daughter's current schedule of access with you, but more importantly, given her current developmental stage. She's 5 years old. And your schedule at 5 years old is different than at 3 years old, and it will be different than 8 years old. And in terms of the very last step of the way, in other words, if you've tried everything and you simply can't get there with discussions with your ex, then the answer is you can bring a motion to change. It's found under the Family Law Rules, Rule 15, and the Section 29 of the Children's Law Reform Act says if there's a material change in circumstances that pertain to your daughter, you have a right to bring it back to court and ask for a change in your current schedule. And Rule 15 of the Family Law Rules sets out the process. What are the forms? What are the steps necessary in order for you to ask a judge to make a change? And one more thing I'm going to just add to you is that we, fortunately in Ontario, have an office that helps parents address disputes regarding custody and access, and that's called the Office of the Children's Lawyer, another phrase that you could Google on the internet. And if you and your ex cannot agree on what the schedule should be, you can go to court and ask for a social worker to be appointed to you. And the social worker will then, if the case is accepted, will investigate, speak to you, speak to your ex, speak to your daughter, speak to your daughter's teachers and daycare providers and so forth, and then recommend a plan for the purposes of a new access schedule.